Morning, brothers and sisters. We start with a collect for All Saints' Day. Almighty God, you've knit together your elect in one communion and fellowship of the centuries past to the centuries to come, according to your promises to Abraham, Isaac, and Jacob. Your covenant, your mercies, your salvation comes to all your people infallibly by your omnipotent hand. So give us grace to follow the apostolic and prophetic word of the canonical scriptures, that we may walk humbly and in all virtuous living, so that at the last we may come to those unspeakable and grand joys that you have prepared for your people in the future, but which we have today as a foretaste, and all the great benefits we enjoy this day, through the might and majesty of our omnipotent Redeemer, Jesus. Amen. Well, we read verse 5 of hymn 479. Lift ye then your voices, swell the mighty flood, louder still and louder, praise the precious blood. Well, we resume our work on the law of homicide in Perkins and Boyce's criminal law. We're getting into the weeds, as these lawyers do. It's one of the things I enjoyed when I took the criminal law course, was the amount and degree of thinking and sifting and nuancing and equivocating and back and forth, but in the search for the remedies of justice. This began with Brother Dutch Gilson and I talking about what do we do with the Marian deaths of the English Reformation, or has since arisen since that discussion, the homicides and deaths of those in the first 3 centuries of the apostolic and post-apostolic church, or the attempted murder scheme of Haman and Esther, or the attempted murder scheme of Pharaoh with the Hebrew midwives in Exodus 1 and 2. So I don't want us to get lost in the weeds and miss why we came to this study. And even with our Cranmer studies, we've got to ask some unpleasant questions about his involvement and his culpability in the death of John Frith in July 1533, and then John Lambert in 1538. So we'll try to keep that. We don't want that to get lost while we fall out of our knapsacks as we wander around in the woods, in the forest, in the glens, the valleys, and the mountaintops of this salutary volume on criminal law. So now today we start with the place and time of homicide. And we pick up, we've already started that, so we jump into the middle of his discussion. Fortunately, no such narrow view prevailed, and the judges recognized frankly that the crime of murder or manslaughter, which will be defined later, starts with the cause of death is inflicted but is not completed until the resulting loss of life. And if it becomes necessary to pick one occurrence or the other for some special purpose, the choice is dictated by the nature of the inquiry. If, for example, where capital punishment had not been authorized, a statute was enacted establishing the death penalty for murder. This could not be applied to any offense previously committed during the period where the death penalty was not in effect because of the ex post facto prohibition. If, however, a murder was committed when a death penalty statute later found to be constitutionally invalid was in effect, if a death penalty statute is therefore promulgated which meets the constitutional requirements, murderer prosecuted under the latter statute could be punished by the imposition of the death penalty under the new statute without contravening the prohibition against ex post facto laws. Oh, these lawyers. The earlier statute is viewed as serving as an operative fact to warn the murderer of the penalty which the state would seek to impose on him were he convicted of first-degree murder, and therefore complies with the ex post facto provision of the United States Constitution, with the footnote to a federal case in Florida. And if the statute was enacted after the fatal blow was struck, but before the resulting death, it would clearly violate the underlying principle to apply the new punishment to this case. Hence, for this purpose, the homicide is said to have been committed at the time of the defendant's act. On the other hand, this hand, on that hand, on the other hand, which hand are we talking about? These lawyers, man, they got a bunch of hands. You gotta love it. It would be unjust to convict one of being an accessory after the fact to murder because of the help given to the wrongdoer while the victim was still alive. And we're going to want to ask that about Cranmer particularly. Was he an accessory to the first-degree homicide? Who really bears the responsibility in John Frith's homicide? I think we can call that. We certainly can call it that by the definition given. A homicide is the death of a human being by another human being. Somebody takes somebody's life. It's real simple, it's really broad, but we're dealing with a homicide. What kind is it? What degree? What are the penalties for that? How? And from a theological standpoint, what does God view or say? Do kings like Henry just get to lop off heads? So far of his purpose, the murder dates from the death of the victim. A Kentucky court reached a contrary conclusion based upon the particular language of a Kentucky statute requiring that the accessory merely have knowledge of a felony. And that is, it's got a Texas court ruling as well. The defendant had knowledge that the victim had been shot, although not killed, which was enough to satisfy the statute. The court acknowledged that absent the statute of common law rule was the knowledge of death was required before one could be convicted of being an accessory to homicide. In other words, a statute was not enacted before the murder unless it preceded the act of the defendant. So far as criminal law is concerned, homicide is divided into two classes: innocent homicide and criminal homicide. And that's an important distinction. For example, some guy breaks in my house and I see a gun and I pull out my 9mm and lock and load and take him down. That's an innocent homicide. I am not guilty of criminal homicide, but because of the fear and the threat to my own life, plus we have the castle doctrine here in North Carolina. You invade my home, you scare me. And I fear for my own life, so pop, I cap you in the head. I am not guilty of criminal homicide. Certainly it's an innocent homicide. It's one I hope never have to face. You get the point here. So it's making the distinction, innocent and criminal. Innocent is when I have to go into a combat zone and kill a Taliban or Islamist, or go into Germany in World War II and kill Hitler's boys. Nobody likes this, but there's a place for justifiable homicides, or a police officer who's threatened in the takedown. And of course, all these little boys and girls, these little nihilists on the streets who are uncritical, untaught, unlettered, emotionalists that we're seeing, Anyways, I digress. Now we're talking about innocent homicide, and we'll shortly be talking about criminal homicide. Innocent homicide as a matter of criminal law means homicide which does not involve criminal guilt. Whether a killing class is innocent homicide in criminal law might, under some circumstances, impose upon the slayer an obligation to pay damages in a civil action need not receive attention here. Innocent homicide is either two kinds, justifiable or excusable. Homicide is justifiable if it is commanded or authorized by law. Okay, so maybe get into the combat stuff. The two typical instances in which homicide is commanded by the state are the killing of an enemy on the field of battle as an act of war and within the rules of war. And two, the execution of the sentence of death pronounced by a competent tribunal. In certain other instances, a homicide may be duly authorized by law, although not actually commanded by the state. The typical instances are killings which are necessary in 1, arresting a murderer or some felons or preventing their escape or recapturing them after escape. 2, the lawful self-defense against an assault which places the slayer in imminent peril of death or great bodily harm. 3, actual resistance of an attempt to commit a violent felony such as rape or robbery. Homicide which is neither commanded nor authorized by law is excusable if committed under circumstances not involving criminal guilt. Common illustrations include killing as the result of an unfortunate accident by one who is neither criminally negligent nor engaged in any unlawful act at the time. 2, death caused by a firearm discharged by a little child. 3, homicide by a raving maniac. 4, certain killings in self-defense. The self-defense cases offer a nice distinction between the proper use of the words justifiable and excusable as applied to homicides. Suppose one, himself free from fault, kills an assailant under the firm belief that this drastic act is necessary to save himself from death or great bodily harm. If the killing really is necessary to save him from such grievous harm at the hands of a murderous assailant, it is authorized by law and hence justifiable. Well, we come back to Cranmer, his situation. The king had commanded the death of Anne Boleyn. Nothing he could do. He tried to intercede for her. How about Lambert and Frith? What could he do to stop that? So we got a question of any criminal involvement here. It's a lot harder than it seems on the surface, right? On the other hand, if he was in danger at all, but was the victim of a practical joker with a rubber dagger, who played his part so effectively that the victim realized he was in imminent danger of being killed, the law does not authorize the killing, but the homicide is excusable because of the reasonable mistake of fact. So suppose some huckster or some thief goes into a convenience store and he pulls out a plastic gun, black plastic, and it looks real, but it's not. And the cashier or owner of the joint sees this fake gun. He pulls out his gun and shoots the man, even though he's not in actual danger because it's a plastic gun. And he shoots and kills the man, the potential robber. It's an excusable homicide. He has the profound fear of bodily harm. Or suppose a murderous attack upon an innocent victim sufficient to authorize him to kill his assailant, but the shot fired for that purpose misses the assailant and kills a bystander. The law does not authorize the slayer to kill the bystander, but if the fatal shot is fired without criminal negligence, the homicide is excusable. Well, now we turn to not away from innocent, excusable, justifiable homicides to criminal homicides. Criminal homicide is homicide without lawful justification or excuse. And here's where maybe Cranmer can hide. Well, the king ordered it. Just one offense under the ancient common law of England. It was divided into two crimes, manslaughter and murder, several centuries ago. Certain statutes played an important role in this division, but these are so old that murder and manslaughter are empty creatures of the common law, so far as this country, the U.S., is concerned. In some jurisdictions in this country, an additional category of homicide, negligent homicide, has been added. In many instances, the substance of this crime is the substance of manslaughter at common law. Well, now we turn to murder, B. At common law and traditionally in the United States, murder is homicide committed with malice aforethought. And as you can imagine, there's going to be a lot of ink out of what malice aforethought means. And there's a reference down here to California Appellate Court, Massachusetts, Iowa. And here's at common law, murder was unlawful homicide done with malice aforethought. The Eighth Circuit. It was one of the few felonies under the common law of England and is a felony under modern statutes. Malice aforethought. The phrase malice aforethought is peculiarly confusing to the layman because each word has different significance in legal usage than in ordinary conversation. This will get interesting. Interestingly enough, while the law has gradually whittled away at the original meaning of the second of these words, it apparently employs the term malice with very little variation from its ancient import, whereas the popular usage has undergone substantial change, and malice, mala, is the Greek word which means evil or wicked. It's still used in modern Greek. They'll use it for a dog or a cat, a wicked or evil cat that's kind of unruly. It has a wider sense, but we'll see how this emerges here. One court has observed that malice is a term of art. Contrary to the implication of the charge, the term does not mean malice as used in ordinary language. There has been a trend away from the use of the term malice aforethought in recent legislative definitions of murder. Now for the word aforethought. Undoubtedly, the word aforethought was added to malice in the ancient cases to indicate a design thought out well in advance of the fatal act. But as case after case came before the courts for determination involving killings under a variety of circumstances, there came to be less and less emphasis upon the notion of a well-laid plan. And at the present day, the only requirement in this regard is that it must not be an afterthought. So we turn to Queen Mary and Reginald Pole in Bloody Bonner. They definitely designed Cranmer's death. They thought of it. They knew of it. And Mary was maliciously forethinking this, as was that reprobate King Philip II. A forethought, well laid out plan, premeditated, pre-vetted, pre-considered. Killing with malice is sufficient of itself to negative any possible notion of an afterthought, And apart from the historical background, the word aforethought would not be needed. However, the whole development of the mental requirement of the crime of murder has centered around the words malice aforethought. So at this point, we need to know what's in the mind, the mens rea of the slayer in Queen Mary's case, or in King Henry's case with John Frith and John Lambert, or in Emperor Charles V's case, or in the Medicis in Paris in 1572. That was a pre-considered program and pogrom against the elect French Huguenots. The use of the word forethought, however, must not be permitted to obscure the result. As a matter of law, killing may be with malice aforethought, although it is conceived and executed on the spur of the moment. Somebody said that malice aforethought is the minute you pull the trigger. It occurred a second or two before you pulled the trigger. Aforethought could be a second or two, a minute before. What does it mean, aforethought? Well, for example, if one should find himself alone with a political opponent and should suddenly slay the other with a heavy iron bar which happened to be at hand, the slayer would be guilty of murder even if no such thought, aforethought, had ever entered his mind, and he carried out the idea as rapidly as his thought translated into action. Is that aforethought? What kind of murder is it? Second degree in the heat of passion? We'll talk about that later. Well, we talked about aforethought, and what does it mean? How long is it required? 2 seconds before the killing, or a day or two, or a week or a month? And how are we going to evaluate Bishop Stephen Gardiner of Winchester? He must have been, I wonder do we have evidence of his delight? I think we do, in the death of Thomas Cranmer. As he said, that poor reprobate said at the end of his life, as he lay dying, putrefying sores in the stomach, Peter has repented. I have not. Awful thing. Malice. In ordinary conversation, the word malice conveys some notion of hatred, grudge, ill will, or spite, but no such limitations is incorporated in the legal concept of 82. And this is where it's hard to, we got to understand malice. And there's a California case, a Nebraska case, another California case. And here's the definition of People versus Cruz. The mental state constituting malice aforethought does not presuppose or require any ill will or hatred of the particular victim. Very important. So if we're talking about Cranmer and Lambert, I don't think he hated Lambert. And Frith, he was a Lutheran. I don't think there was malice in this sense with Cranmer. There's no ill hatred, ill will. Here's some illustrations. Might include the case of a mother who kills her illegitimate offspring to hide her own disgrace, yet feeling at the time no hatred toward the baby or any other person. And even while having the yearnings of a mother's love toward an innocent child, loving its life just less than her own reputation. Very close definition there. There may be added the case of a husband who killed his wife at her request because his love was too great to permit the continuance of her suffering from a hopeless terminal disease. Even such cases as these have been held to fill every requirement of malice aforethought. The possibility that acting under extreme compassion might constitute, not excuse, but constitute mitigation seems not to have received enough attention. So we're discussing what malice, aforethought means, and our time has slipped away. And we need to think of those things biblically in terms of systematic theology and church history, but that's why we're reading it, to get the aid and the help of the lawyers on this important subject. Well, we'll come back in a few days, God willing, and until then, Godspeed.